Question 751. The following statements are true regarding exclusive listing contracts, except A. They are employment contracts. B. They note a promise for a promise. C. They can be verbal. D. They are bilateral executory contracts. Correct answer is C. They can be verbal. All listing agreements must be in writing. An exclusive listing agreement includes a promise for a promise, making it a bilateral agreement. Listing agreements amount to an employment contract between seller and broker. The seller employs the agent to find a buyer for their property. In many jurisdictions, there are specific requirements for written listing agreements, such as including the property address, terms of the sale, and commission information. Although verbal exclusive listing contracts are technically possible, a written agreement is highly recommended. This helps prevent misunderstandings between the seller and the listing agent. It also provides clear evidence of their agreed-upon terms. Question 752. It is legally valid for a real estate agent to refuse to show a home to a person of color if A. The agent has a reasonable belief that the person of color would not be welcomed by other residents of the neighborhood. B. The agent is too busy with other prospective buyers. C. The owner specified in the listing that his property showing only be shown in his presence, and that owner is currently visiting another city. D. The agent is not a member of the National Association of Realtors and so is not bound by fair housing laws, nor is his client. Correct answer is C. The owner specified in the listing that his property showing only be shown in his presence, and that owner is currently visiting another city. Fair housing laws, such as the Federal Fair Housing Act and California's FEHA, are crucial to understand. These laws strictly prohibit discrimination in housing. This includes discrimination based on characteristics like race, religion, national origin, and disability. Real estate agents are strictly bound by these laws. An agent cannot base their actions on discriminatory beliefs or prejudices of others. This is a clear violation of fair housing laws, steering. While being genuinely busy is a valid business reason to reschedule, an agent cannot use this as a pretext to avoid showing a home to a protected class. If the refusal is consistently applied to all clients regardless of race, color, it might be acceptable. However, if it's disproportionately applied, it could be discriminatory. Every real estate licensee in the U.S. must follow federal and state fair housing laws. This applies to their clients too, if involved in discrimination. Membership in professional associations like NAR does not change this legal obligation. The NAR Code of Ethics adds additional ethical obligations, but the law applies to everyone. If a seller provides a specific, non-discriminatory instruction about property showings, like requiring their presence, the agent must follow it. When the seller is unavailable, the agent simply cannot show the property. This is a lawful instruction from the client, not a discriminatory act by the agent. The reason for not showing is the owner's specific instruction and unavailability, not the prospective buyer's race or any other protected characteristic. Question 753. A broker owns a property that a married couple wishes to buy. As a condition for the sale, the broker requires that the couple relist the property with the broker list back whenever the couple decide to sell it. Such an arrangement would be A. Valid. B. Valid, if the purchasers pay with cash. C. Invalid under the Sherman Antitrust Act. D. Invalid under the provisions of anti-discrimination laws. Correct answer is C. Invalid under the Sherman Antitrust Act. The broker is engaging in a tying arrangement. This occurs when a seller conditions the sale of one product, the property, on the buyer also purchasing another, distinct product or service, the future listing services. Such a condition forces the buyers to use the broker's services in the future, eliminating competition for that future listing. This is considered an unreasonable restraint of trade and is anti-competitive. The Sherman Antitrust Act, and similar state laws like California's Cartwright Act, prohibits such practices that restrict competition in the marketplace. The method of payment, cash or financing, has no bearing on the legality of a tying arrangement under antitrust laws. Anti-discrimination laws, like fair housing laws, prohibit discrimination based on protected characteristics, race, religion, etc. While tying arrangements are illegal, they are not illegal under anti-discrimination laws unless the condition is being applied discriminatorily. The illegality here stems from anti-competitive practices. Question 754. Which is the best definition of a fee simple estate? A. A life estate. B. Title held by the owner without any restrictions. C. A term tenancy. D. The highest interest that can be held in land. Correct answer is D. The highest interest that can be held in land. A fee simple estate, often referred to as fee simple absolute, represents the most complete form of ownership in real estate. It means the owner has full and absolute ownership of the property, including the rights to possess, use, sell, lease, mortgage, or dispose of it in any legal way. This type of estate is of indefinite duration, it doesn't end automatically, and is fully inheritable, meaning it passes to the owner's heirs upon death. While fee simple is the highest interest, it's very rare for any title to be held without any restrictions whatsoever. Even fee simple estates are typically subject to government powers like taxation, eminent domain, police power, zoning, and escheat, as well as private restrictions like CC&Rs, covenants, conditions, and restrictions, or easements. So, without any restrictions, is generally an overstatement. A life estate is an interest in real property that is limited in duration to the life of the person holding the estate or to the life of some other designated person. It is a lesser interest than fee simple. A term tenancy, or estate for years, is a leasehold estate for a fixed period of time. It is a possessory interest, not an ownership interest, and is far less than a fee simple estate. Therefore, the highest interest that can be held in land most accurately captures the essence of a fee simple estate. Question 755. When prepayment penalty provisions are not included in a mortgage loan, such a loan is called an A. Open mortgage. B. Loose mortgage. C. Non-structured mortgage. D. Lien loan. Correct answer is A. Open mortgage. Loose mortgage is not a standard, recognized term in mortgage lending. While non-structured might imply flexibility, it's not the specific term for a loan without a prepayment penalty. A non-structured loan generally refers to one where the repayment schedule is more flexible or at the borrower's discretion, such as some types of life insurance policy loans, but it doesn't directly define the absence of a prepayment penalty. A lien loan isn't a specific type of loan. A lien is a legal claim against a property, like a mortgage, but it doesn't describe the presence or absence of a prepayment penalty. An open mortgage is a type of mortgage loan that does not include a prepayment penalty clause. This means that the borrower can pay off the loan early without incurring any additional fees. This can be beneficial for borrowers who anticipate having extra funds available to pay off the loan sooner than planned. The promissory note for an open mortgage will usually state the borrower can make the mandatory payment, or more, on the stated payment date, when prepayment is allowed without penalty. Question 756. Under the Civil Rights Act of 1968, someone who feels they have been discriminated against while seeking housing may A. Pursue an action only in federal court. B. Pursue an action in federal or state court. C. File criminal charges in state court. D. File criminal charges in federal court. Correct answer is B. Pursue an action in federal or state court. Under the Civil Rights Act of 1968, which includes the Fair Housing Act, someone who feels they have been discriminated against while seeking housing has multiple avenues for recourse. Victims of housing discrimination can file a civil lawsuit directly in either a federal court or a state court. They do not necessarily have to go through an administrative process first, though that is also an option. Besides going to court, a person can file an administrative complaint with the U.S. Department of Housing and Urban Development, HUD. They can also contact a state or local fair housing agency, like California's Civil Rights Department. These agencies investigate complaints and may help resolve the issue. Housing discrimination under the Fair Housing Act is generally a civil offense, not a criminal one. Therefore, filing criminal charges is not the typical recourse for housing discrimination complaints. Therefore, the most accurate option describing the legal avenues available is pursuing a civil action in either federal or state court. Question 757. James took back a first trust deed from Martha as part of the purchase price for his house. After 3 months, Martha defaulted on the payment. James the seller should A. Bring a suit for damages, B. Foreclose on the trust deed through a trustee's sale, C. Rescind the contract, D. Bring a suit to compel specific performance. Correct answer is B. Foreclose on the trust deed through a trustee's sale. While James could sue for damages, foreclosing on the secured property is the most direct and common remedy for a lender when a borrower defaults on a secured loan. A lender might sue for damages if a property sale doesn't cover the entire loan, potentially leading to a deficiency judgment. However, this isn't usually the first step for a secured lender. They typically prioritize foreclosure to recover the debt. Rescission means undoing the original purchase contract and returning the parties to their pre-contractual positions. This is typically done for issues like fraud, misrepresentation, or mutual mistake, not generally for a post-sale default on a financing instrument. The sale has already occurred, and the trust deed is a separate financing agreement. Specific performance is a remedy where a court orders a party to fulfill their contractual obligations. This is usually sought when a party refuses to perform their part of the original purchase agreement, e.g., the buyer refuses to close the sale. It's not the appropriate remedy for a default on a loan payment after the sale has already been completed and a trust deed put in place. The remedy for a loan default is foreclosure. Question 758. The person named in a written power of attorney to legally act for someone else is usually referred to as an A. Principal, B. Fiduciary, C. Agent, D. Attorney in fact. Correct answer is D. Attorney in fact. The principal is the person who grants the power of attorney. An attorney in fact is a fiduciary, meaning they hold a position of trust and must act in the principal's best interest. Fiduciary describes the nature of their relationship and duty, not the specific title given by the power of attorney document. Agent is a more general term for someone who acts on behalf of another. An attorney in fact is a specific type of agent, but attorney in fact is the more precise and commonly used term for someone acting under a power of attorney. A power of attorney is a legal document that gives one person the power to act for another person, the principal, in legal or financial matters. The person designated to act on behalf of the principal in a power of attorney is called the attorney in fact. This individual does not have to be an actual attorney, lawyer, to hold this role. Question 759. Mary, who is a minor, was left a property in her father's will. Mary then signs a grant deed to Sydney to deliver the property she owns. That property conveyance to Sydney is A. Valid, B. Voidable, C. Valid, if the property is worth less than $5,000, D. Void. Correct answer is B. Voidable. In California, a contract entered into by a minor, a person under 18, is generally voidable at the option of the minor. This means the minor can choose to cancel the contract before reaching the age of majority, 18, or within a reasonable time thereafter. However, when it comes to contracts relating to real property, California law has a specific rule that provides even greater protection for minors. Under California Family Code Section 6701(b), an unemancipated minor cannot make a contract relating to real property or any interest therein. This makes it unenforceable by either party against the minor, and the minor doesn't even need to take action to disaffirm it. The value of the property does not change the minor's lack of capacity to convey real property. Question 760. One big difference between a real estate option and a regular contract of sale is the options. A. Automatic expiration period of 1 year. B. Irrevocability. C. Mutuality of obligation. D. Lack of mutuality of obligation. Correct answer is D. Lack of mutuality of obligation. In a standard purchase agreement, there is mutuality of obligation. This means both the buyer and the seller are bound to perform. The buyer is obligated to buy, and the seller is obligated to sell, assuming all conditions are met. If either party breaches, the other can sue for specific performance or damages. An option contract is a unilateral contract. The seller, optioner, is obligated to sell the property to the buyer, optionee, if the buyer decides to exercise the option. However, the buyer, optionee, is not obligated to buy the property. The buyer merely pays for the right to buy within a certain period. Because only one party, the seller, is bound by the promise to sell, there is a lack of mutuality of obligation until the option is exercised. Options do not have an automatic expiration period of 1 year. The duration of an option is typically negotiated and specified in the option agreement. It could be for a few months, a year, or longer.